Thanks everybody for coming and participants for joining and wonderful panelists and Biza for Kate for helping to organize all this. So this meeting was conceived when the applications were filed for arrest warrants in the ICC last week. This seemed to the co-conveners of the ILPG working group sort of an important inflection point in both the ICC's investigation, the situation in Palestine, and also broader international, legal engagement in the Israeli-Palestinian conflict, and of course the current Israeli-Hamas conflict in Gaza. We're very fortunate to be joined by a tremendous panel today. The approach that we're going to take, I think, is I've invited the panelists to provide some opening comments, their top 2 or 3, let's say, takeaways from recent developments, and introduce themselves at the same time, because you're going to hear them, not me. We'll then have some structured discussion. I think roughly I've got 4 themes in mind that we'll see how it develops. And then, depending how that goes, we'll hopefully open up to Q&A. So I'd invite you, throughout the discussion to put questions into Q&A field, which you should see at the bottom, near the bottom of your screens. And we can then try to organize these and put them to our panelists. It'd be lovely to hear your voices and see your faces. I don't think the format permits that. What I would ask is that, given the sensitivity of the topic, the subject, that the panelists and everybody else, if you're putting questions to Q&A, please do try and be respectful and sensitive and constructive as far as possible. So in terms of timing, why don't we go around our panelists in the alphabetical order, introduce yourselves, say, maybe give us your top 2 or 3 takeaways from recent events, and we can safely broach beyond the role of the ICC in light of the ICJ decision, and more broadly what we're seeing is quite a dynamic situation. So yeah, emotions run high in the subject. I think our aim here is to try to make sense of current affairs. So with that, who's going first? I think Kevin, you're up. Kevin John Heller.
Thanks, Henry. So yes, I'm Kevin Heller. I'm professor of international law and security at the University of Copenhagen Center for Military Studies. I also serve, perhaps more relevantly for today's event, as the special advisor on war crimes to the ICC Prosecutor, in which capacity I've been involved in the Palestine investigation for a number of months. I'm obviously a bit limited in what I can say about the process that culminated in the applications for arrest warrants, but I do want to make 3 kind of brief points in my opening remarks. And if they sound self-interested, well, they are. First, the applications have resulted from what I think is a very thorough, rigorous, objective investigation. Although Israel turned down the prosecutor's repeated requests to enter Gaza, the Palestine team has nevertheless been able to develop considerable evidence relevant to the guilt of the suspects named in the applications. That evidence is very diverse. It is mutually corroborating. It includes testimonial evidence from survivors and families of victims, as well as from doctors, lawyers, journalists, NGO workers, etc., on the ground in Gaza. It includes digital evidence, much of which we received directly from witnesses and victims through our OTP link, and we received an unprecedented number of submissions. We've relied on satellite imagery, and we have relied on mutually consistent statistical data produced by a variety of national and international organizations. We believe that the evidence far exceeds the standard in the Rome Statute for an arrest warrant, quote, reasonable grounds to believe that a crime within the court's jurisdiction has been committed. And in fact, I think we believe that it exceeds even the much higher standard set as a matter of policy by the prosecutor, that of, quote, a reasonable prospect of conviction. Second, and I really want to emphasize this because this has been the source of a lot of questions, it is important not to read too much into what is not in the applications. The applications reflect the suspects and the charges for which we felt we had sufficient evidence at the time the prosecutor decided to file the applications. Full stop, end of story. We have not ruled out any specific charges. We have not ruled out any specific suspects. And indeed, it is highly likely that there will be additional suspects and more charges against the current ones. As the prosecutor has said publicly, we continue to pursue multiple interconnected lines of inquiry. And third, and here's my most argumentative, please do not be fooled by Israel's claim that it was blindsided by the applications and that the prosecutor did not give Israel sufficient time to pursue domestic accountability. The prosecutor has tried diligently to get Israel to engage substantively with him for more than 2.5 years, literally since the very beginning of his prosecutorship. The prosecutor has repeatedly warned Israel that he would move forward if it did not change its behavior, making public statements to that effect in Cairo and Rafah on 30 October 2023, Ramallah on 2 December 23, and at the Assembly of States Parties on 4 December 2023. Even so, even despite making all of those public statements, the prosecutor continued to investigate for another 5 months before filing the applications, and much to the frustration of numerous states, NGOs, and activists. As for domestic accountability mechanisms, Israel did not ask the court to defer the investigation when it had the opportunity to in 2021, and it has never given the office any indication whatsoever that it is actively investigating Netanyahu and Gallant for substantially the same conduct as the OTP, and that is the complementarity standard. And so I'll just end with a reminder that if Israel does choose to engage with the process, they still have the ability to challenge admissibility on the grounds of complementarity. And in fact, they have the right to even challenge the court's jurisdiction and ask it to revisit the 2021 decision by the pretrial chamber that serves as the basis of the current investigation. So with that, I'll close my opening remarks.
Thanks, Kevin. Okay, alphabetically, who's next?
Sorry, Maria.
Victor Katana, you're up, right?
Thanks, Henry. Thank you. Thanks. So I'm an assistant professor in public international law at the School of Law at the University of Nottingham. But in an earlier time, about 12 years ago, I was a legal advisor to the Palestinian leadership in Ramallah, where I briefly dealt with what was called the ICC file. So my thoughts on recent developments: I think this is a very bold and courageous move by the ICC prosecutor Karim Khan, especially given the recent revelations in the Guardian newspaper regarding pressure, intimidation, and phone hacking that he and his predecessor Fatou Bensouda were allegedly subjected to, which all demonstrates the sensitivity of the issues we're discussing. And of course, this is actually, I guess this resonates with me because it was an issue that affected my life when I was a legal advisor back in 2012, when my communications were intercepted and released to discredit ahead of a UN fact-finding mission. But I want to go back to 2012 because it was an important year. That was the year Palestine was conferred non-UN member observer statehood at the United Nations, and it was from that moment that it became possible for Palestine to accede to treaties, which included the Rome Statute, although Palestine did not accede to that treaty until January 2015, was an Article 12 declaration backdating jurisdiction to the 13th of June 2014. And the whole issue about Palestinian statehood, if you like, was rekindled during the first large-scale conflict in Gaza in 2009 during Operation Cast Lead, when the PA Minister of Justice submitted an Article 12-3 declaration in an attempt to confer jurisdiction. That led to a whole discussions with the then prosecutor, which is why Palestine then went back to the United Nations. So in other words, access to these courts, or to the ICC and other courts, is very much linked to statehood. So I thought it was very fitting that in the same week as the prosecutor issued the request for arrest warrants, 3 states, Ireland, Norway, and Spain, announced that they would recognize Palestine, and they have formally done so today. And so as a result of developments over the past 15 years, we are effectively seeing Palestine's legal strategy coming to a crescendo with allegations of serious crimes before multiple courts. It's just a shame it took an awful situation in Gaza to take here. So we'll be discussing mainly the issue before the International Criminal Court, which is currently focused on Gaza, but could also include developments in the West Bank. The prosecutor mentioned this in his interview with Christiane Amanpour, and the panel that was published, the report of the panel of experts of international law also explained that they were aware that additional crimes are under investigation and are expected to lead to additional applications in the future. And perhaps we can discuss what those crimes might be later on. I should also mention that the ICJ is also looking at, although it's a different court, deals with state responsibilities, also looking at the issue of genocide as well as apartheid. And apartheid's been raised in the advisory opinion proceedings. Genocide has been raised in the case South Africa instituted against Israel. And then my final thought is that despite the optics that we saw last week in the press briefing by the prosecutor, mentioning Hamas leaders first and their crimes, and then Israeli leaders, in my view, if warrants are issued, they're more likely to affect Israeli leaders simply because they travel regularly to ICC member states, especially in Europe. And I think it would have less of an impact on Palestinian leaders of Hamas, who are already on multiple terrorism watch lists, and you've been watching their movements since at least 2015. And also those states that support Hamas are not members of the ICC. So in other words, despite the focus on Hamas, I think it's going to have much greater impact on the Israelis, and therefore it's not surprising that they've been very concerned about this move for some time. And I'll leave it there. Thank you.
Thanks, Victor. And over to our second Victor, I think.
Thank you, Henry. Thank you to BISA for organizing this event. I'm Victor Peskin, the other Victor. I'm an interdisciplinary political scientist at Arizona State University. And I've been following issues of state cooperation with and state defiance of international criminal tribunals for a long time. So I see this situation in comparative terms. So just some comparative thoughts here. Almost all targeted states, such as Israel now, or targeted entities such as Hamas, will seek to shift the narrative and put an international tribunal on defensive and prevent the state's isolation in the wake of investigations or requests for arrest warrants and indictments. So the ultimate aim of most targeted states, there are some exceptions, is to undermine the legitimacy of international tribunals in order to maintain the state's international standing, and of course, to undermine the prospects for criminal accountability against state suspects, especially a head of state who might be under indictment. So we see that across many cases in Serbia, Croatia, Sudan, Kenya, and this is no exception. How do states try to accomplish the aim of undermining international tribunals? Sometimes they share strategies, and sometimes states innovate and use different strategies. In this situation, we know from the allegations in the Guardian article this morning that sometimes attempts to undermine justice and accountability are done covertly with alleged threats, as we see in this report. Other times, the effort to undermine tribunals, and we see this with the comments of a number of Israeli leaders echoed by some in the US and other countries, are to undermine the legitimacy of the pursuit of justice, is to effectively argue that this pursuit of justice is actually allegedly a perversion of justice. In effect, to knock the international tribunals and their chief prosecutor off their moral pedestals in order to prevent the isolation of the targeted state, and of course, to prevent arrests and eventual trials. Shifting in a comparative lens, a targeted state's best outcome is, in a way, what happened with Sudan and Kenya. Of course, to those state leaders, an indictment is not a best outcome, of course. But once the arrest warrants were issued, subpoenas in the case of Kenya, the effort is aimed at bringing international attention and their regional peer groups. So in the case of Sudan and Kenya, the African Union, and to build that regional solidarity, and to really try to undermine the credibility of ICC, which we really saw with the potent attacks against the alleged unfairness of the ICC's then largely exclusive focus on Africa. With Israel, we see also an attempt to rally its Western allies, and we see this through some arguments that that, as we see, you know, a quote I'm drawing upon, that Israel calls on, quote, civilized nations, you know, to rally to its defense, right? So here we see an effort on the part of the Israeli government to argue that it, as a democracy, is waging a just war and is embattled, and the pursuit of charges against its two leaders are unjust. So all of this is aimed toward, you know, advancing the moral stance of the targeted state, Israel in this case, against the tribunal. So I will be looking closely, as a lot of us are, at the role of ICC member states, especially EU states, to see, are they going to go all in for Israel, right, like the AU did for Bashir in Sudan, or are they going to press the state to hand over the two would-be suspects, as we saw with a strong EU conditionality policy with Serbia? What we see now is the EU is split. It's somewhere between the strong solidarity of the AU against the ICC and the strong solidarity of the EU in support of arrests.
Thanks, Victor. Noelle, I think you're up.
Hello, so my name is Noelle Kenive. I'm a professor in international law at the University of West of England. So I'll focus on what exactly Kevin said we shouldn't be doing, which is looking at the statement and trying to understand the statement from a legal perspective. So sorry, Kevin, I'm going to do this and you can tell me off. So first thing I looked at is the crimes that have been mentioned. So there's a list for each group. So on the side of the members of Hamas, we have a number of crimes being mentioned. Most of them relate to September, the 7th of October, but also the treatment of the hostages. What actually I find quite interesting in that long list is the extermination as a crimes against humanity, and the fact that also they have murder mentioned in there. And we know that murder and extermination are alternatives. It's either or. And the very difference between them is simply the sheer scale of the killing. So my question was more whether the prosecutor was thinking that maybe extermination was not going to work and murder was a fallback position in case the pretrial chamber would not go for it. I don't think it should be, because looking at all the jurisprudence, there are good reasons to believe that it would fall within the concept of extermination. Missing from the list, I have found that there is no reference to the sexual violation that have been alleged to be committed on the 7th of October. But again, the prosecutor says that he is still looking into this, investigating. So that is pretty much sure to come. What I found a bit interesting is that persecution does not feature there as a crime against humanity. I would have expected this, given that the attack was against the Jewish civilian population, and also listening to the rhetoric of Hamas. So, but as Kevin said, don't read too much into it. Maybe more is to come. For the second part, the crimes that are alleged to be committed by the two members of the Israeli government, pretty much everything is on starvation. It's actually quite interesting to look at this. It looks like the prosecutor has tried to find each single legal provision in the ICC statute that could pretty much in any form fit into starvation, because probably starvation, well, and we know that has never been prosecuted before, so we actually don't know what is the scope of starvation as a war crime, rather than that as a violation of international humanitarian law. What is missing in there, in that part, I would say, is pretty much all the nitty-gritty in the conduct of hostilities, but we also know that this is quite difficult to prove, and we've seen this with the situation in Ukraine also. It took quite some time for the ICC to actually, come back and say, yes, in fact, we need to look at the conduct of hostilities. My second point, and that is something that Victor mentioned, that the ICJ is looking at the issue of genocide. We don't find it in the application for the arrest warrants. We always have this discussion. We had it also in relation to Ukraine, as to why, there is no arrest warrant for genocide, probably again, because it's easier to go for crimes against humanity and war crimes than it is to go for genocide because of this high threshold and this intent, specific intent that needs to be shown. Again, we might actually see a change there. I remember the ICC the ICC prosecutor in the al-Bashir case, listing, in fact, genocide, charging genocide, then was actually fucked up by the pre-trial chamber and came back, and eventually they got it. So, you know, it took 2 years, but maybe there's some chance there, but we'll get something on genocide too. My third comment relates to the modes of liability. So both groups have been charged as co-perpetrators and superiors. It's quite interesting to see the parity, and it's something that also is mentioned more or less by the prosecutor in his statement. And also he mentions that he's looking for those who are most responsible, which is an interesting way to formulate this. So he's really looking at the top of a chain. And again, I can see some links here with what has been done in relation to Ukraine, you know, going for really the top fruit rather than the frying fish. So that's my comments. Thank you.
Thanks, Noel. Ido, over to you.
Yeah, thank you. So I'm Dr. Ido Rosenzweig. I'm Director of Research at on Terrorism, Belligerency, and Cyber at the Minerva Center for the Rule of Law Under Extreme Conditions at the University of Haifa. And I'm also the chairperson of ALMA, the Association for the Promotion of International Humanitarian Law, an Israeli-based NGO. Before I go to my 3 points, I just want to say briefly that I've read the articles on The Guardian today, and I'm very concerned about what I read. If what has been described there is true, this is completely awful actions by the state and should have not have taken place. And this is not the way a democracy should act towards agents of the court. Okay, so after saying that, the 3 points and the general agenda I want to address today are the fact that the prosecutor and the court are not acting outside of the political influences and political reality of the world. And I think that the high profile nature of this conflict has significantly affected the way the prosecutor has reacted to it. We can also look at it from the ICJ, but this is outside of the scope that we are talking right now. And I think that one of the biggest questions that derive from the high profile of the conflict is that if the prosecutor is not going to respond quickly and vigorously towards all parties, he will have to answer the big question of what are you good for? If the entire world is talking about that conflict and the ICC won't address that conflict, even though they have jurisdiction, and I'm going to put the entire controversy about jurisdiction aside, my opinion aside, for the OTP, for the prosecutor, there is jurisdiction over this situation. And therefore, if the prosecutor has jurisdiction, clearly, if they won't address that, what are they good for? And I think that has influenced a lot of the decisions by the prosecutor. And I divided to 3 perspectives in my main approach. One is the purpose, one is the impact, and one is the process. With regard to the purpose, the biggest question that I keep thinking about over and over following the request for arrest warrants is that why are we asking for arrest warrants? Why the prosecutor is asking for arrest warrants, fully knowing that they won't be implemented? I mean, I don't think anyone here on this panel has a doubt that if the arrest warrants are issued, then Netanyahu and Gallant will never step into the territory of a member state. And as Victor Katan said earlier, the leaders of Hamas, Ania, Sinwar, and Def are already on a watch list, and they are being blacklisted, and they won't go into a member state anyway. So knowingly that these arrest warrants are not going to be implemented, why so quickly? Why now? Why this situation? And I think that the what are you good for aspect has a lot to do with the decision to request those arrest warrants. And that's on the purpose. On the impact, briefly, I would say that I'm sure that the prosecutor has taken into account the impact of requesting their arrest warrants on the situation, but there's still the question of knowing that the mere fact of that interference in the situation might have an implication on the interest of justice, on the interest of victims. And the interest of victims, I'm talking about the Palestinian victims and the Israeli victims including the people outside in Israel territory subject to rockets by Hamas, and also the hostages that are being held incommunicado, basically in forced disappearances. By the way, enforced disappearances wasn't included in the arrest warrants requests so far. Hopefully, in the development, as Kevin suggested, will include that violation. And I think that part of the impact is putting them side by side, also being fully aware that it will shift the entire discussion towards the Israeli politicians, because clearly everyone knows that the leaders of Hamas have some involvement in the in war crimes and crimes against humanity so far. So the big question was whether or not there will be a request on towards Israeli officials, and lastly, on the process, as I'm really trying to be brief as always. I think that the entire notion of the entire process and going fast on the one hand and trying to be over-inclusive on the other hand has led to two sub-issues. One is the entire notion of notification that, Kevin, you addressed briefly 2 minutes ago when you said that the prosecutor has notified Israel in 2021. Well, the crime of starvation wasn't relevant in 2021. And most of the crimes that are relevant now weren't relevant in 2021. And I think that this is a whole new process, and a formal notification in accordance to Article 81 and trying to following the entire notion of complementarity should have been played to the fullest here. And so also on that point, I won't go further on that because we're trying to, again, be brief. I will also lastly say about the classification of the conflict, the complicated classification of the conflict of placing international conflict next to non-international conflict. And I refer the viewers to a very interesting discussion on just security written by Yuval Shanin and Michal Cohen, so I won't have to go through all of them, but there is a question of the choice of equivalent two types of armed conflict, which might not be practical on the ground, just in order to get to some of the crimes, in order to make sure that things are being implemented. And I think that if we take all that, the purpose, the impact, and the process into account, and we look into the political influences that the reality has on the prosecutor, we can see that if he hasn't gone through that specific channel of making all the choices, acting quickly and all that, he would have to answer to the entire international community to the question, what are you good for? And I think that this is the way it rounds up to the decisions of the prosecutor, to my opinion, at this point. Thank you.
Thanks so much, Ido. And I think last, but certainly not least, Maria, you're up.
Thank you very much, Henry, for inviting me in this wonderful panel. My name is Maria Varaki. I'm a lecturer in international law at the Department of War Studies. And long time ago, I was an international criminal lawyer. I have my own experience from the International Criminal Court as a visiting professional when I completed my PhD on the interest of justice. Now, having said that, this is the most I can say. No, I would say that I'm a little bit careful with words. Lately, I feel that I'm in the fiction of Albert Camus, The Plague, where there was a character who couldn't complete the letter because he couldn't find the perfect words to describe a situation. And I feel to be in this way. I don't have the perfect words. And to be honest, I challenge myself constantly, not to mention the article we read, all of us today, a couple of hours ago on The Guardian. Clearly, I feel very limited because I don't have the complete picture. I would say I have an incomplete picture. So based on that, I would like to share questions and some thoughts. I don't have strong statements because I don't feel secure, safe enough, strong enough to make, confident enough to make those statements. So first of all, I would like to say that generally I'm a little bit skeptical about grandiose projects, such as the project of international global justice, as the famous first prosecutor of the International Criminal Court used to call it, Luis Moreno Ocampo. I'm more interested in the limits of international criminal justice because I think it's more interesting, but also it's more cathartic. Having said that, my thoughts during the last 10 days are skeptical thoughts. And here I would like a little bit to problematize the audience and to share your thoughts with me, with you, about the skepticism I have, seeing an attempt of rehabilitating the image of the court. And that comes into two fronts, I would say. The one is about the relationship between international law and politics. I think our audience and all of us, we are beyond this discussion, if it exists, and how intertwined is international criminal justice and politics. But mainly an idea that a perception that this time law is applied not selectively, equally, compared to other notable cases and occasions, and there is truth to power for first time via law. So I was a little bit problematic with this image of the court, knowing, for example, notable cases of political pressure. We all know that politics is inherent within International Criminal Court. Who are we kidding at this stage? And not to mention the cases, the situations of Iraq and Afghanistan, where we haven't heard anything on Afghanistan the last period. Now, having said that, maybe I'm wrong about that, but this idea of selectivity, which is inherent within international law, and especially within international criminal law, I think it deserves a more nuanced approach. My other skepticism is very much related to the legitimacy. And in the panel, there are three people who have worked on a project on legitimacy, Victor and Henry. And I'm not going to deal with this concept, but the question was, if we go into that legitimacy to the eyes of whom, and have we rehabilitated the perception, the legitimacy of the court before in one constituency, but what happens towards other constituencies, and what that implies at the end of the day for the future of the court. And within this broad, very complicating context, I would call it even an asymmetrical context, what does it mean at the end of the day for the lives of the real people? So moving beyond the abstract, I go to a more specific. I said before, I'm more interested in the limits of international criminal justice, and I would like to quote here the late Tom Frank, who wrote that loopholes are bad, but also very important because they can save law from itself. I would say loopholes are very important because they can save an international criminal court from itself. So I would like to make the bridge between the abstract and the individual. And I believe that we all refer to the court, but at the end of the day, we talk about particular choices. We talk about the prosecutor himself currently, who exercised his prosecutorial discretion, took a particular decision to proceed with a request for arrest warrant, and proceed also with particular statements. So there is a massive issue of responsibility here for me, not only about individual criminal accountability or where we talk, but the responsibility of the institution, and if you want, responsibility of the individual. And this is part of my work about ethical responsibility, or what we call it a responsibility toward of someone who is a leader of an international criminal court or international organization. And here I would like to believe that when the prosecutor and his team decided to pursue with the request for the arrest warrants, we know very clearly, all of you, that we have this wonderful provision on prosecutorial discretion, the interest of justice, in Article 53, 1C, to see. And I want to believe, and I believe so, of course, it's one of the elements, at least, if we go into the policy paper, both of the interests of justice, but also the policy papers of case selection and case prioritization, that it was taken under consideration. This particular prosecutorial discretion requires, I would say, individuals who exercise what I call it phronetic judgment, courage, and honesty. And I really want to believe that for the sake of the people on the ground, and not for us who participate in a panel from London or Amsterdam or Glasgow, that the people at the Office of the Prosecutor who decided to proceed with this particular request, they took under consideration these parameters. I want to mention something here, and maybe Kevin will help me a little bit with that. I was surprised, I can say that with the policy consideration, please help me, on the case prioritization that unless it's not adopted or applied now by the OTP since 2016, that one of the criteria, apart from the legal criteria, it was the operational criteria. And one of the operational criteria has to do a little bit with the feasibility of the operational feasibility. And I wonder to what extent this particular criterion, to what extent you can have actual a prosecution that can conclude with an effective prosecution. You say that the prosecutor himself believes, that it can go towards that direction, that if that was taken under consideration. And I stop here to say I started with Albert Camus and the plague. And Albert Camus, somewhere in his famous fiction, he says that maybe, the answer to all this mess, in that case was the plague, was decency. And maybe he said it sounds like a ridiculous idea, but I believe that it is the answer. So I really hope that whatever it has been decided or whatever it will be pursued from now on, it will be based on the principle of decency, not for the abstract level, for the actual people on the ground. Thank you.
Thanks so much, Maria. What I planned to do now was to sort of cover these four broad thematic areas that the panelists and I had considered earlier. So I wonder, Maria, if we can perhaps park the particular request for Kevin to come in on justice until our second theme, which is totally relevant, but I'm also aware there are probably constraints in what Kevin can say, although I won't put him on the spot. But I will put you on the spot, Kevin, because I was curious. You sort of laid out quite carefully the party line, I think, where the applications came from and the process and at least the weight of the evidence. And Noel, you had some really interesting comments, I think, on what was in and was not included in some of the in the application. So I wonder, Kevin, Noel, would you want to just restate some of the key points on the ambit of the application, perhaps, and then we can put it to Kevin for his thoughts? Would that be all right?
Was it addressed to me first?
I thought Noel might wish to perhaps amplify slightly her thoughts on the contents of the applications, and then to Kevin perhaps to respond to that, and then others.
Okay. No, I was trying to understand which crimes were on the list, which crimes were not on the list. So there is the list, but also there's the entire speech, the statement of a prosecutor, and it gives a steer into really what is being covered there. So, for example, I noticed that the word in the context of captivity was used quite often. So that gave the impression that these crimes were in relation to the hostages and the treatment of hostages. Those the ones which were at the beginning of it were in fact relating to just the 7th of October. I might be wrong, and that's why I looked at the violation of sexual violence, and I noticed that then the prosecutor said, well, that is something we're still looking into it. So my question to Kevin is that correct, that there is this sort of the first three crimes are relating to 7th of October and the rest is only relating to hostages? Because I could see how the other ones could also apply in a captivity context.
Okay, very quickly, Kevin, before you speak, I should have said the theme for this sort of looking at now is what the applications, the content, the timing, the context tells about the ICC's approach to the situation. Sorry, I foregrounded that. Second thing, Kevin, before you answer, folks, please put in questions to the Q&A tab. We'll pick them up probably in 20 minutes ago, depending how we go. Over to you, Kevin. Sorry about that.
So, I mean, there are limits on what I can discuss, but by the same token, I can certainly explain some of what we have done because it's on the paper. You're absolutely right that we have a very categorical distinction between the treatment of hostages in captivity and anything that might have happened on October 7th. As I said before, that our choices are a reflection, of, well, primarily the available evidence within the time frame that the prosecutor had set for filing the application, and also, of course, just the inherent legal complexity of certain crimes, and some crimes are more legally complicated than others. And again, we have not said we will not pursue any of the crimes. We have simply said that at this moment in time, they're not charged. And the prosecutor has been very open about that, particularly the sexual violence on October 7th that was allegedly committed by Hamas, that will be part of our future inquiries. And again, nothing should be read into it other than sometimes it's easier to investigate things that are happening in captivity than in the heat of horrible hostilities. One thing that you didn't touch on in this last comment, but you said earlier, again, it's just to kind of explain the relationship between the starvation and the extermination charges and then the murder charges. You can think of them as a logical progression. Starvation doesn't require actual starvation. It's not a crime that has a consequence element. It is simply when you block the humanitarian assistance with the necessary intent, that completes the crime, even if by some miracle nobody actually suffers as a result of it. So that's the war crime of starvation. But then, of course, when the starvation actually leads to deaths, then you're in the realm of the other crimes. And so in terms of murder versus extermination, and what you said was basically spot on, the international jurisprudence is not completely clear about what the minimum number of deaths is to qualify for extermination. Probably for good reason. Courts have never wanted to say, oh, it has to be X number of people who have died. We think that by any standard, the allegations in the application far exceed it. But nevertheless, out of an abundance of caution, we have argued it in the alternative. And similarly, and this would be the last thing that I say, and kind of going back to something that was said by Ido earlier, you also don't know everything that is in the application by reading either the panel report or the written statement. And I don't think I'm giving away trade secrets if I say, in terms of things like conflict classification, there are plenty of arguments in the alternative. We try to cover our bases, not knowing exactly what perspective the judges will take, especially in a situation in which there is so much debate about how to classify. So again, just don't assume that something isn't in the application because it isn't in the very, the short written statements that the public has seen. And I'll stop with that.
Thanks. So that's really interesting and helpful. Noel, anything further from you think on this front, or anybody else in the panel for that matter? Content, timing, or context? We can revisit some of these. Okay, we have that. No, I see Maria and Victor Catan. Victor K. Maria, please.
Maybe Victor, we keep the alphabetical order. Victor, go first, please, if you want.
Sure, I'm happy for you to go first, Maria.
Okay. Again, it's more general, my comment, about the context. And I think this is something I would like to grant to the ICC, that if we compare the ICC proceedings for now, proceedings meaning what we have, and the ICJ proceedings, where there is lots of discussion between law and narratives, I have to give lots of credit to the ICC, because this is there is a context over there, whereas with the ICJ proceedings, we have a more limited focus. Of course, it's based on the Genocide Convention, we know that, and there is lots of debate regarding the context, whereas with the ICC, there is an acknowledgement of the context, as Victor Catan described before, from the accession all the way, and before even the accession. And I think this is a very important indicator So that's it.
Thanks, Maria. And Victor, did you
I can
want
say
to
something? Yeah, I mean, the timing. I know there was a lot of criticism from Palestinians and other global South scholars on why the prosecutor took such a long time. But of course, one issue is getting evidence from an active crime scene or an active conflict, which is also something that's affected the ICJ proceedings. And I was just reading this morning the latest opinion from last Friday, which the court make the point that the complete refusal to allow independent investigators in Gaza entails a risk that the true number of Palestinian casualties will remain unknown, and moreover that evidence will be obliterated as a result of Israel's ongoing military operation. So I think that's one of the reasons for the timing. I'm kind of intrigued. I don't know if Kevin can talk about this or anyone else. I mean, how does the court get evidence? I mean, obviously there's satellite video, that there's interviews with victims and the like, but I'd imagine that at some point you want to send people into Gaza to gather evidence. So I don't know if that was a consideration.
Kevin,
explain the delay.
Thank you, Victor. Kevin, I don't know if you can spot, but do you want to come back on that point, or perhaps on the question of how operational likelihoods and strategic, effectual plays into?
Well, if you don't mind, I mean, I'd love to just touch briefly, because it was both mentioned by Maria and by Ido, and I think it's an important point to address. And my first comment would be, if the ICC only issued or applied for arrest warrants in situations where we were absolutely certain we were going to get the suspect, or we had the suspect in custody, we would have a very, very, very short docket. I haven't gone and done an exhaustive study, but I don't know, we haven't had what is it, Erdemovich or Tadic, who was already in custody when the court decided to proceed, the ICTY. But I think at a deeper level, what I find, I guess, troubling about Ido's point is that we're somehow expected to assume that no state is ever going to fulfill its international obligations. I don't think we can build that into our thinking. It is probably true that the Hamas suspects are unlikely to end up on the territory of a state party, but certainly as the prime minister and minister of defense of a West-leaning state with Western supporters, how can we just assume that every country in the EU would not actually exercise our arrest warrants? So is it likely? Do I think that any of the suspects are going to end up in the dock anytime soon? Probably not. But at the same time, we've seen this again and again and again, whether we can start with the Milosevic's and Taylor's and Karadic's. The arrest warrants go on if they're issued forever. There is no statute of limitations for war crimes and crimes against humanity. And so if we feel we need to proceed, we have to let all of the forces that are completely beyond our control determine whether we end up having somebody to prosecute or not prosecute. So in that sense, that is our operational approach, I suppose, to address Maria's point, that we can't necessarily assume lack of cooperation. I know that's not a satisfying answer, Maria, but that's kind of the best I can give.
Ido, you also come back in as well, on that point, or?
Yeah, just briefly, one to Kevin's last point. I don't think that I'm expecting any state to disobey its international obligations. I said that I think that Prime Minister Netanyahu and Minister of Defense Gallant will not step foot in any member state territory. So then we're talking about what are the obligations of non-member states with regard to the arrest warrants, and that's a completely different questions about their obligations towards that. And with regard to the timing, I do have a question about, I mean, there is some reasoning that, I mean, some of the violations that Hamas is being, that were made against the leaders of Hamas were relevant even before October 7th, towards previous rounds of escalations previous conflicts between Israel and Hamas, situations in Gaza, etc. But the OTP hasn't chosen to address them previously and only now. So Victor Catan said at some point that why it took them 5 months to address it. There is a lot of criticism about that. But when we look at the general modus operandi of the ICC so far, 5 months is quite fast, it's quite quick in that sense. So I'm not sure that, it goes back to my initial comment of what are you relevant for if that big conflict that everyone is talking about it isn't being addressed by the ICC. And within the context, one small question, if I may, to Kevin, the whole notion of the intent of starvation versus the reality on the ground, for at least for the first days of the first weeks of the situation, where Gaza wasn't necessarily under full belligerent occupation by Israel on the one hand, and the levels of water being transferred from Israel to the Gaza Strip were quite low in comparison to the complete. So that during the first days, at least, where the first period where the arrest warrants also already referred to, there wasn't necessarily a big shortage, a significant shortage of food or water in the Gaza Strip. So the question of intent was in comparison to the statements raise an interesting questions about how can you claim for starvation at that point. Thanks.
I don't know if Kevin, you respond to that. You don't need to. I've got plenty.
Just very briefly on the two things, because I don't want to make this just a referendum about me. So well, first off, I can't get into the evidence on intent. I would just remind the audience that we have the burden of proof. We have to establish a reasonable basis to believe at this stage. We have to have clear and convincing evidence if we get to the confirmation of charges stage, and ultimately if we have a suspect, we will have to prove it beyond a reasonable doubt. Again, we would not have brought these charges if we didn't think that, at least at this point, we already have a realistic prospect of conviction. The only thing I would say about timing is, it's kind of arbitrary what you choose as your baseline. I can't speak for previous OTPs. This prosecutor has only been in office since 2021. He had no sway over what Luis Moreno Ocampo or Fatou Bensouda did in the investigation. This investigation was opened very shortly before he became the prosecutor in June of 2021. And if you date it from the beginning of the investigation, it's actually closer to 2.5 years and not 7 months. So even if we have a baseline ordinary practice, which I also don't think we have, just choosing October 7th as our first date, I'm not sure that that's the appropriate baseline.
If you don't mind, Noel, I see you, and do you want to come in quickly? And because we're totally over time with what we hope to cover.
Yeah, in relation to the crime of starvation, it is, like Kevin said, it's conduct based. So you have to show that that is the purpose is starvation. And what we can see is that the longer you wait, you might have more evidence, in fact, to show that that was the intent. So the timing was indeed maybe to wait a bit in order to gather that kind of evidence. So, I mean, at the very beginning, like Ido said, there was less water and so on and so forth. But then when you start also to impede any relief operations, then, you start to stack up evidence to show that there might be an intent still to be proven. So in terms of the timing, I can understand that it took a bit of time, but I think it is very quick when you compare to any other previous prosecutor who took really a long time before, going for arrest warrants. And we've seen in Ukraine, the first one, was rather quick, though it was a year, and then the next one took another year, and that was in relation to the conduct of hostilities. So I think they were quite fast here,
If I may, thank you everyone for that. I'm going to suggest we move on slightly. The second sort of theme that I thought we might discuss is what might the applications augur for the ICC and the broader field of international, let's say, rule of law, the endeavor of international rule of law. This perhaps relates back to, Maria, your point earlier, and also some of the points that Victor K made as well. So that's on that broader background. I think you mentioned the broader context of passive legal strategy. Does this suggest that the strategy is working? If I can pick up on that one, Victor.
Let me start. Okay. Strategy working. Too soon to say, but I mean, I think I described it as a legal crescendo in the sense that you've got multiple cases now at the international level and the domestic level overlapping. You have the ICC warrants. The ICJ has, I think, 3 cases in relation to. You've got South Africa against Israel, Nicaragua against Germany, and then you've still got this old case, Palestine against the United States of America, which wasn't about Gaza, but it could be. I guess it could be restarted if they wanted to.
And the advisory opinion, don't forget.
Say that again.
Really?
The advisory opinion.
An advisory opinion.
Oh, yes.
That's the one I was forgetting. The advisory opinion, which actually I think is potentially the most important of them, and the one that we're likely to hear from the court sooner. And I guess that's part of a strategy to both legitimize the Palestinian claim in terms of increasing numbers of countries recognizing Palestine as a state, and also to bring. So I mentioned earlier the big crime, I think, apart from genocide, is which has been raised in the advisory opinion proceedings, but not in the other cases, is apartheid, which is also a crime against humanity, as you know, under the Rome Statute. And it's interesting to see. So this is a global South. These are global South states that have made this claim before the ICJ. I think about 20 countries have come out and gone into some countries like Namibia and Qatar and South Africa have asked the court to assist them with defining this crime in customary international law, which if they were to do that, and it's speculation because we don't know what the court might say, but if they were to take that invitation and to say something useful, it could have a ricochet effect on these other cases, whether domestically or at other international tribunals. So I think that the Palestinian strategy, it took 15 years to get here, and I mean, one must ask, if it hadn't been for October the 7th, would the prosecutor have taken such an interest? And that's kind of the perverse side. What's going on is that this shocking act of violence, and what's happened since is really, we still live in a primitive legal society in which violence is still the issue that gets states to move and do things. If it hadn't been for that, I think we'd still be waiting for courts to do something. So the strategy appears to be working at the moment, but it's too early to say where it might lead. And it's no succor for all the Palestinians and Israelis that have died in the meantime. It would have been much easier if the negotiations process, which died about 10 years ago, had gone somewhere, but that was not the case, as you know.
I have some thoughts myself here, but I wonder, would anybody else jump in this idea of implications for the broader, international rule of law project, if we can say that? And Victor, this is very much your field. Yeah, go on.
Sure, I'll jump in, and I don't have an answer to the question, but of course, this situation is very remarkable, right? It's the third situation, in addition to Georgia and Ukraine, where you have warrants sought outside Africa, but this is the first situation where you have leaders of a Western leaning or a Western state indicted all the way at the top. I mean, the request for indictments. I think a key issue with the health and credibility of international human rights and international criminal justice is, will Western states, the US especially, but not only the US, will these actors also hold their Western allies to the same level of scrutiny and enforcement? And we see with the discussion of the possible reapplication of sanctions in the US, we see that the US is deeply ambivalent on the question of equality of the law for its allies. And for the EU, I think we'll have a battle, and deep discussion over that. So I think it raises a question for Western states, and that also reflects on the question of enforceability for ICC warrants as well.
I want to just pick up off that. I wonder if I might. It seems to me there are two if you like, broad brush approaches that can be drawn from the discussion we're having so far. One is what we're seeing is a system working as it should, right? These institutions are doing their job. It's the ICC, the ICJ, cases are coming, they're making decisions, they're operating, they're stepping in. On the other hand, I'm thinking of Maria, what you said earlier, and perhaps Ido, we're also seeing the limits of these institutions and the system. So to me, what's quite illustrative, on the one hand, in one way, is the the immediate impact, perhaps, of the ICC applications, which has added, if you like, or caused perhaps a rally around the flag phenomenon within Israel. So that's what you were saying, I think. On the other hand, we've also got this latest ICJ order, which is ambiguous, and that ambiguity can enable it to be used as a sword, right, to sort of say, hold up to Israel, so you must do this, but also a shield. The ICJ has not ordered clearly a ceasefire on ambiguous terms. Therefore, query that's therefore a shield, perhaps, for Netanyahu and co to say, well, we can keep fighting if it wasn't, we weren't told to stop. And I'm not arguing question of good or bad faith here, but just to point out, are we seeing the system working and its limits at the same time? Is there anything, broader, if you like, that we can derive from these observations, or am I being too abstract for this discussion? Maria, hands up. I open this up.
Thank you. Well, I think, as I keep saying to students, words do matter. And we saw the phrasing of the ICJ, first with the plausibility. We saw the former president of the ICJ saying, we didn't mean that, we meant plausible rights. And then we have about 1,000 interpretation of plausibility. And now we see a very different interpretation of the last order of Friday about Rafah, although I think the events yesterday and today, I mean, the Security Council has a meeting, I think, very, very soon today. I think Rafah is a situation that evolves so rapidly with whatever happens on the ground. I had a question actually about that. I still believe that there are many limits, and it's fine to deal with the limits. I believe acknowledging the limit of international justice, whether it's the ICJ or the ICC, I repeat myself, it is cathartic, and maybe it makes us more honest and more pragmatic in many respects what it can be delivered. But I would like to ask Victor Katan that, and to others, let's say that we have a repetition of the ICJ that we had with Ukraine and plausibility, after the provisional orders on genocide. And we know what happened with Ukraine. At the end of the day, what we have is that Ukraine has to prove that it didn't commit genocide, Let's say that we have something like that before the ICJ, later proceedings. What is the impact, I would say, for this legal crescendo that, Victor, you described before? Because we're talking about different tribunals. However, the starvation is a component, okay? It can be analyzed within the crime of genocide. And I wonder what could that mean if we have a repetition of the Ukrainian, in my case, fiasco, if I can say that.
Before we bring in Victor K, can I just ask, Ido, you had your hand up, and also Victor Peskin. Do you want to jump in, Ido?
Yes, I want to address 2 points. I think the second one will somehow collaborate with Maria's, but the first one is regard to the ICJ recent ruling from last week. I don't think it's ambiguous. I know that there is a discussion about the syntax and everything, and by far I'm not the biggest expert on the English language. I've never been one, but I do need to. I don't know how to read law. And when the court is saying a sentence, and you have dissenting opinions and declarations, etc., and all of them, one by one, are actually saying that Israel is not requested to stop fighting in accordance to IHL, in accordance to the laws of war, and not for its purposes for the release of the hostages, but not to violate the Genocide Convention. I think that this is a very clear and simple reading of that provisional measure, and it wasn't ambiguous. I mean, the use of the comma here and there could be analyzed either here or there, but when you have the added value of the declarations, I think that there is, and no one actually said otherwise among the judges in their, they had the options to add declarations, to add either dissenting opinion or whatever, and they chose not to. It's clear that this is the interpretation of the situation. I'm not saying that Israel should do everything, and immediately I call to Israel to reduce to surgical operations and not to do whatever has been done in the last couple of days in Rafah, which was awful. And the second part, which hopefully collaborates with Maria's impact question, is to what extent should the ICC and the ICJ take into account the impact that their decision would have on the parties to the conflict, keeping in mind, for example, that we are not, I mean, there are two sides to the conflict, but either one of them is playing in different ways. One is hopefully a law-abiding state, even though what we saw today in The Guardian might raise some questions about that. And the other one, Hamas, is using the law for its advantage and through different violations. Some of them are already included in the request for the arrest warrants. And I think that we've seen on the ground that every time that there is a step towards some of these proceedings in the ICJ or the ICC, there is a step back in the willingness to negotiate to some kind of resolution between the sides, including some kind of a deal to release the hostages. And then, so I'm thinking, to what extent those tribunals should take into account their impact on the situation on the ground and not only withdraw to the bare legal question of, do we have jurisdiction or not? Do we have, all the criteria for arrest warrants or not? But actually have some kind of a bigger perspective over the situation.
If you don't mind, Kevin, I know you've written already, and others have also, on the precise parsing of the last ICJ order. So let's park that, if we may, for the time being. And thanks so much. Victor, just before you come in, I wonder, because you would respond to Maria, right? If before we do that, time is tight. I'd like us just to think in this next round, perhaps, about, on the one hand, who and what are the key constituencies that will affect how this all plays out and what will shape the approaches. So you suggested it should perhaps be strategic context, the conflict itself. I think that's one possibility, but let's see. So what are the key constituencies who will affect how all this plays out? And the second point is, what is the likely range of outcomes and pathways to these outcomes for this case? And we can also think about the conflict more generally and how the court cases interact with that. That's an awful lot to put to one round of questions, but we are super short of time, and Kevin does have to run. So, Victor, I'll call you first if you don't mind, because you're already prepped to respond to Maria's last thought, and then open up more broadly if that's okay.
Sure. So if I understood Maria's question, so in a nutshell, what if the ICJ case under the Genocide Convention doesn't go the way Palestine expects? Okay. Well, that's obviously a big danger with that strategy, but you take risks. It was a risk trying to go to the UN to get statehood, to join all these human rights treaties, which also apply to Palestine as well. And I think the specific case, I mean, the more strategic case, I think, is the ICJ advisory opinion proceedings. The genocide one was primarily a reaction to what happened Israel in October, but I think we're still quite a long way from a decision on the merits there. I mean, in some ways, I'd rather they don't win that case because of what it would imply. But in terms of key constituencies, Henry, I mean, I think, again, for Israel, it would be the West. For Hamas, it would be certain members of the Organization of Islamic Cooperation, Arab League, the Muslim Brotherhood network, which we don't really think about when we think of international law, but they're like key, right? Palestine being the branch of the Muslim Brothers in Gaza. So how those countries, Turkey, Malaysia, Qatar, react and whether they continue to support Hamas would be very germane in that regard. And I'll leave it there. I'll let others speak.
Thanks so much, Victor. And I wonder whether other Victor or second Victor on constituencies that might affect how this all plays out or help shape this all play out and likely range of outcomes. You know, you've got this, you're the comparativist, right? What's your sort of takeaway here?
Yeah, I think that, you know, as I foreshadowed at the start of the roundtable, I think a targeted states peer group, right? So the African Union in the case of Sudan, the EU in the case of Israel, it's not the exact comparison, can have a lot of influence on the narrative about the justness or lack thereof of the ICC action. So if arrests are a long way off, the action then shifts to the politics of the narrative over if this is pursuit of justice or perversion of justice, right? So this is the debate happening, right? And so I think the peer regional group, you know, we know where the US stands, but with a number of EU countries, we also know where they stand. But that, I think, would be key in terms of either amplifying Israel's argument against the court or not. So I think that's where we should also look, not exclusively, but also to the role of the EU and like-minded states, Australia, New Zealand, and other very pro-ICC states.
Thanks, Victor. Other colleagues, other views, constituencies, range of outcomes and pathways. Maria, you've also been studying multiple cases over the years. I think everybody here has. Kevin, I can't put you in the spot with this question, can I? Are you able to speak to this without your ICC hat on?
No, I mean, but I think the ICC hat is a valuable one here. I mean, our constituencies are the state parties, and we don't expect them to necessarily agree with all of the decisions that we make, but we expect them to honor their obligations. And I actually think we've been, or I'll speak for myself, nobody else, I've been pleasantly surprised at the statements that have been made. I didn't think Germany would issue anything that bordered on a positive statement, and yet they did. You know, we're not going to have too many Norways and Frances who simply say we will execute any arrest warrant if Netanyahu comes on our territory. But we value any statement by states that they will comply with their obligations. And, you know, again, I think the US, of course, is the wild card. I mean, they have been cooperating with the court in a number of ways. And I hope, you know, despite all of the bluster, that the kind of the sheer hypocrisy of you know, Joe Biden, you know, praising the arrest warrant against Putin and the US Congress actually allocating money to the courts to conduct its operations, you know, that they can see the double standard that is being applied here, and that hopefully it will not be quite as catastrophic of an impact on us as, you know, some people are either expecting or predicting.
And one of the questions that occurs to me in all of this is to what extent courts themselves have agency, right? Because we're talking about other constituencies beyond the courts, being states, governments, and society, what have you, but parties to the conflict. But there are also the courts themselves and their ability to shape the narrative, to shape their own outcomes relative to that. But I want to park that, much love to go into, because we're totally out of time, 15 minutes left. I'm going to pick up some of the Q&A, if that's okay. I'll put some of the questions from the Q&A to our panelists. So I'm giving preference to non-anonymous questions, because yeah, I think it's good when people sort of are identified. So a question procedurally from Richard Annandale: how long before the judges make a decision, and how likely the judges will decide to issue the arrest warrants? This is back to the ICC. How long's a piece of string, or fairly soon? What do we think? Kevin, can you speak? You haven't, I mean, OTP wouldn't know this, I assume, but there is prior practice. We have no views on this one. Noel, have you come across any insights here? Ido, what's your expectation?
Well, previous experience shows us that it's going to take somewhere between a month to a couple of months. I mean, it won't be, I mean, I'm sure that they have a lot of evidence material to read, so they won't rush it. So it's going to take at least a few weeks, like 4 or 5 weeks, up to 4 or 5 months. But it won't be too long. I mean, usually this is the range that has been taken so far in previous instances, and according to statistics so far, again, anything can happen. These are independent judges. They can decide whatever they want. Statistically, they're going to approve it. I mean, according to previous statistics, they are going to approve it, because I think out of 40 plus arrest warrants that has been requested so far, I think only one has been rejected, and later one has been approved after some modifications or something like that. So most likely get accepted.
So thanks, Ido. I'm also okay. And further question from the Q&A. Synergy between the ICJ rulings and opinions and the ICC charges. Do we think that we read across from one court to the other? Is that possible, plausible? And Victor, I wonder if you're best placed to think about that one. Is there an implication? You know, Kevin said we can't read much into what's missing from the ICC application, but more broadly.
You want me to speak, or
if you're able to?
Yeah, I mean, I guess I mean, to the extent that the ICJ opinions and decisions are considered authoritative and are not binding on any other institution, but if it's a reasoned and considerate judgment, it might be influential on other courts, but ultimately it's up to those other courts to decide how they interpret their own statutes. But there might be. I mean, for example, there's this issue that I'm interested in on the crime of apartheid. It's not been included in the current issuance for request for warrants, but perhaps, I don't know, if the ICJ was to be bold enough to say something interesting, it might spur the prosecutor to say, oh, maybe I should look at this as well. I don't know. That's speculation, but it might legitimize the crime, perhaps, and lead to results. But we'll see.
Obviously, Kevin, you may have a view here, but Victor P, you're looking thoughtful. I'm seeing cogitation going on there.
I don't have anything to add on that, but there's a lot to think about throughout.
Well, I do it from a comparative view. You know, we saw cases launched at the ICJ alongside the ICTY being in operation as well, right? Same sort of thing. I wonder if anyone here is certainly a better place than me to, or maybe able to speak to how those cases may have interacted, if at all. Again, Victor P looking thoughtful, but
you mean about the interaction of the ICJ Serbia case and the criminal cases against Serbian suspects?
Indeed.
Yeah, I mean, I defer to others on the panel who followed it more. I mean, it's certainly, I think there were, you know, this is a sub issue of you know, certain evidence that the OTP obtained at the ICTY and, you know, did or did not hand over to the ICJ. So that the actual interaction between those two Hague-based institutions are also important, you know, in terms of the nuts and bolts of building their respective cases. I'm not sure if that type of interaction or lack thereof might shape an ICC case. I just, you know, I guess it would have to involve a genocide charge, a subsequent, you know, genocide charge at the ICC. So I don't know, but just something to think about.
Or perhaps the broader issues around this crescendo, right? This sort of wave of legal involvement, which Victor alluded to earlier. Multiple cases, you know, same sort of state kind of thing.
Yeah. It's just on the legal crescendo. If I could just ask Victor, we may not have enough time. You know, 10 years ago, I was also following, you know, the way in which leveraging, you know, then possible ICC intervention might advance the cause of Palestinian statehood. You know, at the same time, international criminal justice is a blunt political instrument. So, you know, I'm particularly interested in, you know, how this, like the coming together of these cases, the crescendo might, you know, advance negotiations. It's still unclear how that might happen, but ultimately, how these cases together might be converted, into political capital in the quest for Palestinian statehood, is an interesting but unknowable question, right? At the same time, so the two victors are on the same wavelength, I think.
So we're almost entirely and totally out of time. Thank you, Kevin, for hanging for staying with us, and I know you've got to go. Just a quick questions coming from Maoling Hassenkamp. So Maoling's asked, what political effects can be triggered and expected through the ICC's warrant? Are we witnessing top-down judicial activism driven by the Global South to address political inertia in the Israel-Palestine conflict? I think that kind of goes to the same sort of point you've been discussing. Is this are we witnessing a wave of international, I think some might say lawfare, I'm not going to use that term, but it's quite evocative for me, I should. It'll do without the pejorative impact. Is that what we're seeing? Will it succeed? Does this have potential to, as Maoling puts it, address political inertia? Maria, I saw the eyes move there. What do you think?
Oh dear. You used also the word lawfare. Of course, we teach lawfare and warfare at the same time, I think. Well, if you ask someone who works in one tribunal and someone and takes the mainstream position is that we're not a political institution. We apply the law, we apply the statute. I remember Luis Moreno Capo keeps saying that, nothing, no political context. We know that that doesn't work. If you ask me, is that the scope of an international tribunal to trigger political developments? We can talk forever. Personally, I don't think that should be the scope, but it does trigger political developments. There is no doubt about that. In particular, the International Criminal Court, which is the most political judicial institution. It's a sui generis institution. It's 50-50, I would say. I had one. I wanted to say something else, but I totally forgot. One thing which I find very interesting is that, all these years, we have all this critique of the ICC being a hegemonic, neocolonial Western project. Okay, so this goes back to my first comment on rehabilitation, on an attempt of rehabilitation. And it's always fascinating to think that despite of being all these things, it is a tool that it is used, okay? So it is a bad project, the way it was conceived, but still it is a tool that it is used. So I think this is something which I find it particularly intriguing in many respects about the inherent value of an institution which has been characterized for 20 years now as a Western project. And I stop here.
Thank you. Kevin has to go. Kevin, any closing words?
Final thoughts? Yeah, I just, I was a pretty strident critic of the ICC for 17 and a half years before I became a special advisor. And, and now I'm not as free to air my criticisms, of course. But it is, it is important to see how the sausage is made sometimes. And it does look different from the inside. And, so I would be the last person in the world to claim that international criminal law or the International Criminal Court isn't political, because of course it is. But that isn't the same as saying that decision-making either is or should be driven by explicit political considerations. And to go back one of the discussions earlier, I don't know how we would figure out what the implications of applying for an arrest warrant or not applying an arrest warrant is. I have no idea. These are incredibly complicated situations. We can't try to prognosticate, is issuing a warrant going to be a good thing or a bad thing? Is not issuing a warrant going to be a good thing or a bad thing? That is so beyond, even the prosecutor's pay grade, that I'm just not sure it can be a relevant consideration. And I'll repeat something I said in an interview, which is, I was in a lot of the meetings. At no point in time did I ever hear anyone talk about the politics of the warrants. it was discussion about what can we prove, against whom can we prove it, and when can we prove it, and that was it. And you don't have to take my word for it, but it has been a fairly revelatory experience for me being inside the OTP. And again, I was not in previous OTPs, so I can't comment, but I can only comment on the 2.5 years that I've been doing this. So, but thank you so much. This has been a fantastic conversation with old and new friends, and I'm really glad that you held this. So with that, I'll let you guys continue on.
Thanks for joining us, Kevin. Thanks for your time. But sticking to the question though, another couple of minutes left. Merlin asked, do we think the judicial activism will have an impact on the ground, and what that be? What might that be? And perhaps we can close on that thought. What are the most likely range of impacts we're going to see here? If you do one last very quick round, or does anyone want to go first? Okay, Maria says, I see a nod from Maria. So Maria, you're up again.
No, it's not fair. I mean, there are all the other people.
We're going to take turns. You have 30 seconds. Most likely range of impacts on the ground. Okay.
Well, being Greek, I would never say against activism. Let's start with that. I believe in being active citizens. So I consider that everyone should be a political animal, okay, according to Aristotle, and activism is important. Sometimes I'm getting skeptical and worried about the information, the over-information and the lack of information that exists out there, the misinformation, the disinformation. But then I believe that this is the role also of academics like us, the way we teach, how we teach, and how we convey a discussion. I think it's very important to encourage activism, but also to encourage people being skeptical, not cynical, and respectful and humane.
Thank you, Maria. Let's go in reverse alphabetical order. Ido, what do you think?
I think impact. I think that, well, I've talked about impact from different perspectives today. I think if we want to have an impact on the situation, we need to go to, you referred to the constituencies earlier. And I think two major players that need to be addressed or could be addressed. One is the Israeli public, because the Israeli public has political influence within the Israeli system, and we are in the middle. We are in a year-long complicated political situation that started before October 7th on constitutional aspects, and now we have that on the conflict aspect. And if that will have some effect on the political leadership in Israel, it could definitely have an impact on the ground and later on towards the proceedings. And on the other side, I think one of the important aspects is to follow the money and see how you can actually have an impact directly on to influence Hamas, and at the same time, again, have some influence on the ground, which will have some impact on towards a better solution to the situation.
I have questions there, but I'll park them for now because of time. Reverse order, PQ. Noel, over to you. Impact.
For me, the most important impact would be accuracy in language, in legal terminology. I've seen way too many people using words right, left, center, not really knowing what they mean. We're trained as international lawyers to be very specific. I just saw in the chat where some of the people in the audience were asking the difference between a prisoner of war, detainee, a hostage taker, and so on and so forth. So very much impact. I really look forward, if we ever get hold of, them before the ICC, to have a definition of starvation, extermination in that particular context. That would be a huge impact, because we've seen starvation in other conflicts and we've never ever prosecuted this. So yeah, accuracy in language, legal terminology.
Okay, I think it's hard to disagree with that. Victor P, you're up. Still looking.
Yes, real quickly. The question of if the request for warrants and warrants can do heavy political lifting to lead to a better political outcome, peace talks, a more just solution to the conflict. is a big unknown. But I just want to raise one issue about Israeli public opinion and Palestinian public opinion. What can be done in terms of Israel to also kind of shift the narrative to underscore that the chief prosecutor is seeking justice for the terrible atrocities of October 7th, right? Is there room in Israeli political discourse to also focus on that as well? And then in terms of the Palestinian public as well. So can this process trigger empathy in both populations? And might that slowly, but perhaps surely be a basis for a different way of looking at the conflict? It's idealistic, but I just wanted to put it out there.
We do need some idealism at times. And Victor Catan, I don't know if would you say an idealistic input or a more realistic one? Perhaps a bit of both.
I mean, in terms of impact, in terms of as a Palestinian strategy had an impact. Initially, I was going to say I don't know, but I had time to think about it. I think it's having an impact on public discourse. Whether it's accurate or not is kind of beside the point. For example, the issue of genocide now is widely used in a whole range of contexts, particularly with activism as a form of stigma. And I think the way we're going, the way the discourse is going, especially after what happened 2 days ago, the day before yesterday, is increasing articulation or justification to arguments for sanctions. So we're seeing this coming out of various UN special rapporteurs, special procedures, Palestinian officials, human rights groups, and the like. So I think all these cases are this activism, and no one knew where this would have led when it began 15 years ago. Given what's happening on the ground, is leading to a kind of new global discourse, and Israel is portrayed in a far more negative light, even now in the West, Israeli policies, than they were even just a few years ago. We were talking about normalization. Less than 8-9 months ago, between Israel and Saudi Arabia and other Arab countries, and an end to the conflict. This conflict was going to end without resolving the Palestinian issue. That was Netanyahu's big strategy. We can park Hamas and the Palestinian national movement, and we can deal with the other Arab states. This is now blown up in his face, and it's got much broader. The activism is at a level I've never seen before, and I'll end it with that.
All right, I want to sum up to a terrific discussion. Thank you again to all of you for joining us and participating. Thank you to those of you who attended for attending, asking questions. And thanks to Biza and colleagues there for hosting. Much appreciated. I wish you a good evening from Scotland.
Thank you. Thank you all.
Thank you so much, Henry. Thanks to Biza.
Thanks.
Thank you, Katie.
Thank you.
Thanks.